64.
Application number 118 on shoulder 25.
Kiiza versus Uganda.
Good morning. May it please you and please the Honorable Court. Here is the wine. I'm here for the applicant and Mr. Sam.
I can't see them. Respectively.
Respectively, yeah, today the house said Sam is
Mohanji.
Kenneth Muhanji.
And Sam is Mulenga.
Sam.
Your Honor, the respondent state is represented by Senior State Attorney, Mr. Amelie Francis Timothy. This matter, Your Honor, comes up for ruling. The applicant is in court. We are ready to receive the ruling of the court.
This ruling, it is a 33-page ruling. You want me to pronounce each and every word in this ruling? Oh, we shall go ahead with the pronouncing the salient features.
We are interested in the outcome. So the holding of the court is more important than the reasoning, which are 2 hours now. So in the interest of time and judicial ruling would be most welcome.
I think we are. Shall we be not denying the?
You just quickly refer, Your Honor.
Yes, please.
And this being a matter of public interest, the general public might want to know, in very brief terms, how the decision arrived at, whatever the decision is.
Okay.
So a summary will be helpful rather than word for word.
This is a Lubo Judge, High Court. At page 8 is the background of the whole matter. At page 14, the question of jurisdiction in general terms is covered. At page 23 is determination of the bail application. Bail encompasses the release from detention by court of a person during trial or during the pendency of an appeal against conviction. It involves taking a recognizance from the person, consisting of conditions binding the person to appear in court whenever required. The effect of bail is therefore a temporary release from custody pending conclusion of the trial or appeal. This instant matter is an application for bail pending appeal. The onus is on the applicant to satisfy the court. Why? In spite of being a convict in custody, he should be released on bail. As a convict, whatever factors are presented for the court's consideration must be exceptional because the applicant has, at this stage, lost the presumption of innocence Otherwise, it would be against public policy to release such a convict, as it is assumed that the court that convicted him acted judiciously when it sentenced him to prison. See Lamba versus Ora, 1958, East Africa, at page 337. Ordinarily, judicial discretion is exercised within given parameters. Judicial discretion is also defined in the 8th edition of Black's Law Dictionary as the exercise of judgment based on what is fair under the circumstances and guided by the rules and principles of law. When a litigant is not entitled to demand the act as a matter of right. It was observed in the English case of Ara versus Board of Education, 1990, Volume 2 KB 165, that judicial discretion is a matter for court to consider all that is before it and reach a decision without taking into account a reason which is not a legal one. The court objects and limits intended by the particular legislation. The court must therefore apply its judicial mind to determine what, in line with the law, would be fair in the circumstances. It will not do anything that would defeat the ends of justice, nor is to say each an application is considered on its own unique circumstances and merits. The Supreme Court has also consistently reaffirmed determining an application for bail pending appeal as stated in Avindi Patel versus Supreme Court Criminal Application versus Uganda, Supreme Court Criminal Application number 1 of 2000. The court added that it is not necessary that all these considerations should be present in every case. A combination of 2 or more criteria may be sufficient. Each case must be considered on its own facts and circumstances. It would also be pertinent at this stage to refer to the Constitution, Bail Guidelines for Courts of Judicature, Practice Directions 2022, where Clause 19 practically reproduces the above decision as guidelines in cases of applications for bail pending appeal. This court is mindful that all these guidelines are not set in stone. Each case shall be weighed on its unique circumstances. I note, additionally, that it would serve no benefit to utilize the provisions of Section 15 of the Trial on Indictments Act, which is cited by the applicant in his notice of motion. Trials on indictments and sets out the conditions for consideration when an application for admission to bail before determination of the trial. The paramount consideration in regard to any application for bail is whether, if released, the applicant will report back to court for the hearing of his matter. In Nachiwuge, Rachel Muleke versus Uganda, Supreme Court Criminal Reference number 12 of 2020, it was held that the main criteria for granting bail pending appeal is that the court must be certified that the applicant shall not abscond but will comply with the bail conditions and will be available to attend the appeal. The applicant has stated that following his conviction for contempt of court, he filed a memorandum of appeal. The applicant's memorandum challenges his conviction and sentence by the General Court Martial. The applicant asserts that his appeal enjoys a reasonable possibility of success. Enjoys a likelihood of success, then that would be a factor in favor of the application. The respondent invited this court to disregard any arguments about the success of the appeal because, as argued earlier, this court had no jurisdiction to entertain this application. The question of jurisdiction has been resolved and will not be revisited here. Turning now to the likelihood of success, I have already observed that it would not otherwise be proper to make a finding about the probability of success of the appeal while resolving this application for bail. It is inappropriate and preempts the resolution of the appeal factor when determining whether or not to grant bail pending appeal. The only means a court can employ to assess the possibility of success of the appeal is by perusing the relevant record of It is therefore imperative that a perfunctory assessment of the merits of appeal is made. The ruling of the GSM indicates that the applicant was counsel representing one Colonel retired Dr. Kiiza Besje in General Court Martial case number UPDF /GSM /040/2024. The GCM found him in contempt of the court and sentenced him to 9 months in prison. This account appears to be the only available record of the court proceedings that day. It is clear that the General Court Martial cited the applicant for contempt in the face of the court. It is a type of contempt of court that has been defined in essence as conduct that denotes willful defiance of or disrespect towards the court, or that willfully challenges or affronts the authority of the court or the supremacy of the law itself. See Kavanaugh, Civil Liberties and Criminal Contempt Power, 1976 to 1977, Volume 19, Criminal Law, Quarterly, page 349 and page 350. It is also what is described as direct contempt, which the 9th edition of Black's Law Dictionary defines as contempt committed in the immediate vicinity of a court, especially a contempt committed in a judge's presence. A direct contempt is usually immediately punishable when the transgression occurs. As part of the definition of contempt, Black's Law Dictionary says the following example. Contempt is a disregard of a legislative or judicial body, or an interruption of its proceedings by disorderly behavior or insolent language in its presence, or so near thereto as to disturb the proceedings or to impair the respect due to such a body. The UPDF Act provides for contempt of court. Section 171 regulates civil and criminal contempt generally. However, Section 1712 speaks to direct contempt by persons before or in the presence of the court martial, which would include advocates. It states, where an offense under this section is committed at or in relation to a court martial, that court martial may, by an order signed by a member of that court, order that the offender shall undergo a term of imprisonment or detention for a period not exceeding 30 days. This is the penal section that sanctions or punishes violations or offenses committed in the face of the court martial.